Morning. Welcome everyone for this webinar on intellectual property awareness. It's my pleasure to introduce and welcome our guest of the day, Mr. Sathya Sundar, on behalf of our college and department. Mr. Sathya Sundar works as consultant in intellectual property matters at Robert Bosch Engineering and Business Solutions. He is a graduate of LLB with specialization in intellectual property law from Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. He also holds a bachelor degree in electronics and communication engineering. He has over 6 years of experience in patent drafting, open source software license, IP licensing, and due diligence. He had worked previously as legal patent associate at Narain Tapeta, an IP law firm, and as program analyst at Cognizant Technology Solutions. With this with this short introduction, I invite you, sir, to present the webinar. Please post your queries in question and answer box that is there below. At the end of the session, it will be addressed to all of you. Now over to Mr. Sathya Sundar. I welcome you, sir.
Good morning, everyone. First of all, thank you for this wonderful platform to share my knowledge with everyone. So it is lovely to be here. So let me share my screen. I hope it is visible.
Yes, sir, it is visible.
Okay.
You might have to go on full screen mode, otherwise it's visible. Yeah.
Is it better now?
Yeah, it's seen clearly.
So if we are in difficult times, I hope everyone is safe and sound. So with that, let me extend my gratitude to the management and especially Dr. Tulsibai and Dr. Kavita Balavargan for having me here. So for the course of next 45 minutes to an hour, I will be discussing today on the topic of intellectual property awareness and how about going patenting the inventions that you might conceive. So as a broad agenda, so the broad agenda would be we touch upon an introduction, and then we get into the different forms of intellectual property. So to appreciate what all subject matter is covered and what what are the protection that is granted under the law. So to appreciate that, and then we get into the detailed manner in patent topic. So finally, we will conclude on what are the career options that is available, in this domain particularly, and then we would take question and answers. So you could post any questions that you might come across during the course of presentation. We'll take it up. So that should be fine. So first of all, we need to appreciate what is intellectual property. So to know that. We just need to first, appreciate the fact what is property. So now, we must have all come across the word property, and we live in a property, we are supported by property. So now, we only need to appreciate that the properties can be of two different categories.
Voice not audible.
Some connectivity issues there, I believe, ma'am, because his audio also was not clear.
Okay.
And now, it's frozen.
There's some problem in his site or what, ma'am?
Yeah, his connectivity is a bit low. When he's sharing the screen and the video, I think it's not.
Okay. I'll let him know then.
Yeah. Might be when he shares the screen, he can be he can turn off the video. Might be you can tell him that.
Okay. Sir, can you turn off your video when you're sharing the screen?
Okay. So is the screen visible?
Your screen is visible, sir.
Okay. So the video is turned off now. So I hope it gives us a bandwidth. So
Yeah, and
I'm not sure where did we.
And your presentation is not up yet.
Not seen. Slides are not seen.
Slides are not seen. Is it seen now, ma'am?
Yes, it's now visible. Might be you can have to put it on full screen.
Yeah.
Yeah.
Okay.
Perfect.
So we'll start from the beginning. I'm not sure where we will break off.
Okay, sir. That's better.
Yeah. So before understanding the topic, intellectual property, we need to realize the term property and appreciate what means property. So property is categorized as real and intellectual. So the one that we are talking about is regarding the tangible and intangible. The tangible category of properties is something you in your day-to-day life, what you the the house that you live in or the goods that you use are all categorized as real properties. Now, inside the real properties, there is a further classification which can be termed as movable and immovable. I'm just picturizing so that categorizing it as movable and immovable, so that you appreciate that in a property there can be a number of classifications. So the house that you live in or the plot is all immovable property. So the other class of properties could be your day-to-day whatever you use, your watch or pen or notebook, or the furniture that is there in the picture too, inside a truck, are all movable. They're not fixed. So, but still you own the title over the property once you purchase the good. So, by virtue of your purchase, you own the title and you can claim it as your property, and whatever rights that is surrounding the property, you are the sole person who can enjoy it. You can prohibit anyone else from interfering into your right. So, this is the other category which we are speaking, which is movable. So now these are all something that you shell out money and someone puts in their effort to create the property, and then you shell out your money to buy it and you can enjoy what's over it. Okay. The other category of property that we are trying to deal with today is intellectual. So the intellectual is something a person puts in his mind effort to conceive an idea, or because of his mind he creates a work. Such sort of property is something that you cannot feel, in real time. So these properties are something which will be categorized as intellectual property, and there has to be laws also evolving to catch up to give better protection to such category of property. So thereby we had to come up with various laws for protecting the intellectual creations of human beings. So I hope this so much is the background that you need to appreciate. So that now in like we saw in real property, we categorized into different movable and immovable. In intellectual properties, again, there are several other categories. We'll go develop into that topic now. So if you see here, these are different category of intellectual property that I have tried to put in the picture. So, to start with, you must have seen all these symbols somewhere in your daily life. So the first symbol, for example, when you see, it is nothing but a copyrighted book. So wherever someone owns copyright over a book, they denote by this symbol, meaning that this work is copyright protected. Now, what sort of work covers under copyright. So that is something that we need to appreciate. So copyright might not cover the entire realm of creation of intellectual subject matters. It has designated subject matter in it. So what is that copyright subject matter? So the example that I can give you is any artistic work or literature, musical work, or programmer writes a program. So the program per se is again a literal work. The language is what is a computer understandable language. However, it is put down on a medium in a paper or in a terminal that computer allows you. So again, for that sort of work, the protection that you get is copyright. So it is, even if a program that you might click in your mobile phone, or a diagram that you write, or a poem that you write, so all these subject matters are covered under copyright, and you can seek protection for them under copyright laws. So in India specifically, when someone writes a poem, so they put in their own effort, they haven't copied from anywhere, they haven't referenced to any other source. They themselves sit and write a poem. So once the poem is written on a paper and it's done, so immediately it is construed to be fixed on a medium, and the protection is rendered automatically. There is no necessity for registration explicitly for copyright in India. So this is something with respect to copyright. The protection of copyright is the author's or the creator's lifetime, and extends 60 years after his lifetime as well. So anyways, that is not a focus topic. We just want to understand what are the subject matter that is covered under each of these protection that is offered. So the next one that you see are in the TM. So both are specifically on one subject matter. Now, R is something, TM you can at least understand. It is nothing but trademark. So, when a trademark application is filed, until it is granted, the TM symbol will be used. But once the application is granted, then the granted trademark will be denoted by R. So, so it is different notions that is being used in industry. So, but trademark is an IP that is awarded for over a period of time. Industry, a player in the industry, he evolves his goods, sells it by so and so brand name, and when you say the brand name, then people normally associate that the quality of goods that comes out of that brand, or the reliability factor, the cost factor. So all those goodwill that a market player has enjoyed over a period of time and gained the confidence of people has to be protected. So his brand name should not be allowed to be used by anyone else in the industry and pass off the goods by so and so person. So that should not be encouraged. To protect this, the trademark offers protection that is required. So the next one is subject matter that we want to deal with is patent. So patent is it covers broadly on inventions. So when we say inventions, there has to be considerable development from whatever is existing in the industry or the market, or someone who is who has knowledge in the subject matter. So there has to be an inventive step, and then something which is not known has to be new. So such and such invention will be rendered protection under patent. So we are talking about inventions when it is patent, right? So then the trade secrets, other category of one thing that commonly can be cited is Coca-Cola. So now Coca-Cola manufactures a drink. So wherein none of us know what are the compounds, what constitutes highly the drink, and what composure all those constants have been mixed to create the drink. So that is kept as trade secrets. Another common example would be KFC. Again, even that it's not known. Someone here it is another logic wherein you in other forms of IP that we see here in this slide, we'll have to disclose the invention, and then government renders protection for you over a considerable period of time. In case of trade secrets, it's a reverse mechanism where you don't disclose the details, but
Hello.
it is kept as hello.
Excuse me, please.
Yeah, hello.
We are not able to hear the audio. Can you please wear the headset and speak because the noise is little breaking.
Is it better or still causing problem?
It is not clear actually.
Actually, many of them have represented saying the voice is not clear. It's breaking. Might be that now can we try? I think second time it was better
Headset.
now.
Headset.
It is a problem, I think. Hello. Hello. Hello.
Yes, sir.
It's okay now. You can.
Yeah, it's better, right?
Yeah, it's better.
So I'm not sure where I broke. Maybe can anyone tell me where should I start?
I think
You
you
can
can
actually proceed. Yeah, you can
yeah, you
proceed.
can continue, sir.
Okay, so I'll continue from trade secrets. So
Yeah.
trade secrets is subject matter which is retained as confidential and it is not disclosed to public. So the trade secret can remain a secret forever. So until unless a company finds that product that it is creating has market value, so until then it can retain the subject matter as secret within the company and within its close employee circle. So the other category that we would look into here is industrial design. This is other, you know, uh, to prohibit replication of design. An industrial design for a particular player, he might have conceived and created a design which would have given the market value, the design itself. So, such design, in order to prohibit other players to replicate it, so this registration has been awarded as protection. So then next one is geographical indication. So this geographical indication, I'm not sure if people would have, in Tamil Nadu at least people, when you associate Tirunelveli, you call it as Tirunelveli Alva. So, it is a close community of people in Tirunelveli. They use traditional mechanism or, whatever raw material that is locally available to create that Alva. So, someone sitting elsewhere, in a foreign country makes the same halwa and then should not be selling it under the name of Tirunelveli halwa. Okay, with that, and to give the protection or to allow the community of people who is living in the territorial region alone to enjoy the right, this sort of IP is protected. So the other example that I can give you is dazzling tea. So I believe the dazzling soil itself gives some value for the tea leaves that is grown there, and also the climatic conditions surrounding that place. So likewise, there are a number of geographical litigation registration that is available in India. So Pashmina shawl of Kashmir. So they have an international reputation. So someone it's easily someone can pass off the goods by this reputation that is enjoyed by its close community, and it is easy for these community people to be rendered without business. So that sort of situation shouldn't be rising. So that is why exactly this it is being awarded. So the lesser known is the semiconductor integrated circuit layout design. This protection basically came into force from 2000, I believe. So this is particularly for the design or how integrated circuit is designed. So if there is a novelty, if it is altogether a new design that has been proposed, then there has to be a protection that is rendered. which apart from patent does not consider semiconductor layout as a particular subject matter to be patented. So that's why a separate IP was drawn out of it and it's been allowed. Other one is for plant variety and farmers' right. So whoever is coming out with a new variety of plant which gives more produce or whatsoever reasons associated with the plant growth or consuming less water or any other factors related to that. So to protect someone on to protect the variety and to also encourage the farmers, this IP is being granted. So let's go into the patent topic, which is real subject matter. So like we already discussed, the patent intends to cover the invention that is conceived by a human. So there are different criteria before obtaining a patent. So it is across world, largely it remains same, but again one has to appreciate that patent is a territorial right. So if someone conceives of invention and if they need to patent it, they'll have to decide on which all territory or which all countries they need to patent the invention. So accordingly, they file patent in all those territories. So it is a territorial invention. So you need to appreciate that. So there is no concept of international patent. You file it in one office and then you are given a worldwide right. That is not simply not there. So, but there are some basic categories for an invention to qualify to be patentable subject matter. So what are those conditions? One is novelty. When we say novelty, it is nothing but an invention has to be new. So new in the case in India, at least they quantify it by meaning substantial increase in inventive step. So nothing, an invention cannot be altogether new or dramatically replaces the human living conditions by introducing so-and-so process or methods. So it's always an invention exists, and there is a problem with an invention, and for that problem you build an inventive step. The inventive step has to be new, and certain that is what is the novelty meaning. And when we say non-obviousness, the other category, that inventive step that you produce is not should not be a process or a step which is easily understandable, or someone from that industry considers this is very obvious, anyone can do it. So it is not something drastically brought in to change lives. So it should not be very obvious is what. So when we say obvious, it is not. It does not cover entire population category. But someone who is specialized in the industry, who appreciates the technical factors, for him it shouldn't have been an obvious thing. So then the next main criteria is that you patent inventions, but what is the resultant of the patent? It should not be meaningless. It has to be a capability of being put in use in an industry or being prepared or made in an industry. So that is a real funda for having a patent or selling out money or effort in having all this. So now basically when we say patent, we'll have to disclose the entire conceived invention. So in a particular format, and then it is recorded and it is published to the entire world. So there is a record of whatever has been invented and conceived. So it does not go missing out of the entire, there is a apocalypse or something. So we'll have to have record, for future generations. So that is the intention behind it. By in way of disclosing this invention, the government grants you a monopoly over your invention to prohibit any other person from making, importing, or whatsoever rights that is surrounding with the patent. Say selling a good made out of the patent or following the process of the patent. To prohibit all these rights that is shared with the patent, you can prohibit the other players from using the patent process. So then the term of patent is 20 years, and I believe some of you at least would be aware of it. So for 20 years, the monopoly is granted to you. So from the date of filing, it extends to 20 years. So when we say date of filing, date of grant of patent might be somewhere down the lane. So patent officers in India are speeding up their process. So but normally I would say it can take anywhere between 3 to 4 years. But your production starts from the day one, that is your date of filing of application. So with this understanding, we'll go further. There is other, we over here we looked into the three main criteria for obtaining a patent. So even there is, you can consider as one other criteria also. The other criteria that we are talking about is subject matter criteria. So now, even if any of the subject matter whatever is listed in here, this is not exhaustive. So, however, if any of the subject matter even qualify to be a novel, non-obvious, and industrially, practical invention. But however, these subject matters do not qualify as being patentable in India. So, for example, if you see here, frivolous or contrary to natural law. So, anyone can claim that there is a perpetual motor is invented by him, and he wants to patent it. So now, if you see a perpetual motor, it goes against the laws of thermodynamics, which is an established law. So it's not sustainable in nature, is what the principle conveys. So any such invention is not regarded as a technical subject matter. So the other example could be the celestial body discovery. So someone discovers a new celestial body.
Hello, can you be little bit louder? Audio is a little bit less again.
Okay.
Is it better now?
Hello.
Yes, no, this is okay. This is okay.
Okay. So someone discovers a celestial body. For such a discovery, so he cannot ask for a patent. So sometime back, Pluto was not regarded as a planet. So suppose someone tomorrow finds a 9th planet and says he wants a patent. So that is regarded as not a patentable subject matter. So any discovery for that matter will not be regarded as a patentable subject matter. So, and any invention which is prejudicial to human, plant, or human animal life will also be not regarded as a patentable subject matter. So, mere discovery of living or non-living substances does not qualify. Method of agriculture, any process of treatment of human beings. So, any treatment on an invention that is conceived for operating a person and curing the disease of a person, it cannot be patented. So the popular, what you can associate is that mathematical models or business methods or computer program per se, algorithm, all these are also not patentable subject matter. So the computer program per se, with your area of expertise or industry, you would have to today, any electronic device or something, it's all can be embedded with a number of excuse me.
Some noise could be heard.
So that was a.
I just checked, sir.
Yeah. So as I was talking, so the computer program is something that you can't avoid. So now you can literally see a computer program does a lot of stuff apart from remaining just a mere program. It can operate a mission. It can have a technical effect on real time, though being a program. So when it has a technical effect, then you can categorize as when it is either bundled with hardware or program alone showing efficacy in terms of making a technical transformation. Then a program can be a method can be categorized as being patented. Otherwise, a normal program which is just merely written on a screen cannot be under protection under patent, but it has copyright protection. So another aspect that we saw is artistic work is again copyright subject matter. It cannot have patent protection. And traditional knowledge, this I'm sure you would have also heard from our film industry. This is one famous case. That patent was granted to turmeric in US. So for the efficacy it produced in healing of wounds. So now, in India, this knowledge was existed among a traditional community for a very long time, saying, turmeric always has this property to cure wounds. and your grandmother or ancestors were always using this as a medicine. So this once it was granted, so, patent rights also include any import or export. So suppose someone has to export turmeric to US soil, then it was causing a problem of infringing a patent that was existing on the subject matter, that is turmeric. So, but Indian government was amazed to see a patent was granted to turmeric, and CSIR had raised an objection in US patent office. Finally, so they were able to submit some documents from Sanskrit text or whatever, usage among the local community, and accordingly it was rendered, it was revoked. So, any sort of technical knowledge for that matter cannot enjoy patent protection. And that is the takeaway. So these are the criteria. So apart from this, also there are a few other subject matters, like you just admixture or presentation, mere presentation. There are a method of horticulture. So or there is a drug that is existing. Medicine tablet. So there is people work on it to reduce the side effects, but the curing properties, that is called as therapeutic efficacy. So when the therapeutic efficacy is not increased just by reducing the side effects, so it cannot qualify as being patentable subject matter again. So there was one very special case in India which is concerning Novartis. So they wanted to extend one of their cancer curing drug. They again worked on whatever patent that they had. When they worked on, they reduced the side effects of the drug, but the curing properties of the drug weren't increased. So by that means they couldn't extend the term of the patent. So that is one criteria. So then let's go into a finer detail of topics now. You need to really appreciate all the law exists, but what is in it for you? Now the process is that you need to be able to be capable of filing patents. Now you on your own have some idea and you are not sure how to go about it. Other one is, how do you come out with ideas or conceive an invention that can be patentable? So for this, some of the tips can be, you can engage in a brainstorming session wherein you can have a particular focus technical area, and with that discussion you evolve with some problem statements or identify the problem that is existing in a field. So like I already said, anything cannot be a drastically complete revamp in whatever technical measures that is existing. So you already know a lot of goods or technical process are already existing. You can narrow down on what is the problem that is existing in that particular domain. So for addressing the problem, now you need to come out with solutions. So those solutions are the one that you can think of being patented. So it is definitely not sufficient just you alone come out with the solutions. Now you need to know whether the solutions can be patentable or not. So in patent, there are different patent databases. So the first database that you can always refer is Google Patents. So and every other patent office across the world also have their own patent databases. In India, this is called INPAS. There is an international organization called WIPO, World Intellectual Property Organization. So they have a large collection of database from different territories around the world. So, but apart from that, you can also there are also paid databases available. So to do a normal search, I would say always you could go with Google or any of the country specific patent office databases. So now the whole purpose of referring to database is at this stage you can think it of as two categories. The one category I would say called as state of art. So now you have identified a technical problem that exists in a field. So now to address that, you need to evolve with a solution. The solution can come out of your own with discussion with a group of people. The other thing is that you can always go back to these database. So find search in with the keywords appropriate for the technical field or the problem, and then see what is the state of art that is existing in the industry. So with that search, you would have the persisting problem and then what are the solutions that is available. So with the existing solution, what is the a better solution that you can propose, which can be in terms of economic value or in terms of efficacy that you efficiency that you produce. So with that you can rule out even existence of any other patent in the subject matter that you are trying to file as a patent. So prior, normally when you on your own develop a solution, and if you want to go ahead with patent, so then the first thing that you need to do is be sure that there doesn't exist any other patent in that same solution that you are proposing. So even before approaching a patent agent to file a patent, you can on your own do this search to be sure, because if something is already existing and you go for a patent application filing, so in all circumstances, an objection can be raised by the examiner and probably the application wouldn't be granted. So in order to invest effort and money in trying to prosecute something which already exists doesn't really make sense. So in order to be sure that there are more chances for you to obtain a patent, you need to carry out this prior art search in a detailed manner. You could refer to all these databases. There are also services provided by a number of firms and patent agents to do this. But before even going to them, I would say, on your own, you should pick up this habit of doing a search, in using these databases to understand if there really exists a patent on that subject. And also, like I told, to develop the solution, also you can just do a search to understand what exists and where are the white spaces where you can focus and build a solution. So maybe this gives you some direction on how to proceed about ideation process of creating an idea which is patentable, which can be considered as invention. So with that, we'll go into. So let's consider now you have an idea which is ready, which is a patentable invention, which you are ready to file. So what are the information that you need to provide to patent office in order to process this and obtain a patent? So we call it as provisional or complete specification. Okay, so this is the document wherein you produce all the details of the invention in a proper structured manner. But on the background, this invention, whatever you're disclosing, it is a requirement of Patent Act that the invention, there has to be a unity of invention. There cannot be more than one inventive concept in an application. So, there has to be strictly one inventive concept in one application, and maybe you can consider filing another application for the other part of inventive concept that you have. So strictly with one concept, you need to process an application, and whatever that you disclose in that complete specification or provision, complete specification has to give out the best method of working that invention. So when you say you have already disclosed the best method in that disclosure, so then such and such disclosure should help a person in that industry to be able to work that invention or reproduce that invention. So the disclosure has to be in such a fashion. So if it is not there, if it does not meet this requirement of best method of working, then there can be an objection raised by the examiner down the lane. So in order to, what we are right now looking at is filing a patent, and at the earliest as possible, be having a grant. So in order to reduce the number of iterations of patent office raising and objections and we having to respond to it. So, it is better in the forefront. You could, obviously you need to engage a patent agent in having this complete specification drafted on your behalf. But what I would say is that you engage and then give out the details in such a manner that the patent agent is able to, create a draft which gives out the complete details as per the requirement of that. I'm sure they would also ask for all these details. I'm just giving an idea that you have to have this responsibility at your end as an inventor. So the next thing is, what are the contents that is generally is part of a patent specification. So the patent specification starts like this. It is first is the title of the invention. The title of invention itself has to, dull and has to give a sense of understanding of what that patent is on. If it is on a method, a device, a method and device for so and so process or something. So, it has to clearly come to an understanding. And next is the field of invention. It gives you the technical area in which the invention operates. And then this background is something which is very important. The background is something where you yourself state what is the existing problem in the market and what is the state of art solution, and the state of art solution that is available today in the market does not address to the problem still persists. And there is a necessity for finding an alternative solution to address the existing problem. So that is what is clearly defined in the background. If at all, by any chance, if the invention that you conceive is disclosed in that paragraph, then it would go into the prior art data. So we would never want to do it. We would strictly restrict to the whatever is existing in the industry, that is the state of art alone. So the summary is just about what you provide, and then there's a detailed description, the description of the drawings that you provide, or the embodiments, the different methods that you operate the invention also can be claimed. So the main part in a patent specification is the claims. The claims is something that they call it, there are two categories in it. It can be an independent claim and the dependent claims. So the claims is a part which gives you the scope of protection. The length and breadth of the claim will determine where you operate. You cannot blindly claim, entire subject matter. Whatever you're claiming has to be restricted to a part. At least the examiner will, see that he restricts your claim to particular scope alone. So tomorrow, when you find someone infringing, you will have to prove that infringement with this scope of the claim on claims only. Whatever you put in other part, that is the description, you could have claimed a number of methods, but that only acts as a defensive. It restricts someone else to patent the subject matter because it is already available. But you can't claim for infringement on someone who has already granted, making products in your domain that you are patented. So in order to be able to claim for infringement, the scope is captured only from the claims. You need to carefully do that. And the next one is drawings. The drawings also is, it acts in parallel with this concept of best method of working. It should enable someone who's going through the application. So you could see the examples of drawing. The first one is the Google Glass, the image is related to that. And the second one is a drone that has come out by Samsung Electronics. So then finally there is an abstract. So abstract will give the gist of the patent, the technical field that it operates, what it plans to achieve. So when normally when you engage with any of the patent databases, the first thing that you receive, you could see on the left the page which is there. What populates is that the main diagram, main drawing for that application, and then the abstract. With that slight reading, you could understand if this patent is related to your whatever you are looking at or whatever you are trying to search. With that, you can conclude that this patent is related or not related. Just go and search for the relevant patent of yours. So I hope this gives some understanding on what are the contents of patent. So next, we'll go into the patent filing process. So the patent filing process, like we already said, it starts with, once the patent is drafted and ready to be filed at patent office. So as the date on which you file the patent application is called as priority date. So later down the lane, if you're filing your priority, first filing the application in India, later down the lane, when you're filing an application in any other country, so it might be 1 year down the lane you file in US, but you can always say that your priority date was from 1 year before, that is the date of filing in India. And in between, if someone has conceived your same invention, you can rule them out from getting a patent, or an examiner in US citing the intermediary period invention as a priority for your application in US. You can rule them out, all those applications. The priority date that you file in India has a lot of sense. Yeah. And once the application is filed, so underneath you can see the time period that is taken. So, there is two applications that we already saw. One is provisional and one is complete. So, complete specification gives out the entire details of your invention, whereas this provisional specification, can be filed at a very nascent stage when you have some concept of invention and some details available. But you know that you need to further work on, require more time to work that invention. So maybe you can consider filing a provisional specification and get this priority date, and you have 12-month period before which you need to finally work out the invention and then file this complete specification. So, in all possibilities, you can as well file the complete specification as your first application. It is your choice, but the law gives you a permissible limit wherein giving you time period to work out invention and still reserve a date for your priority application. So once this complete specification is filed, so from a date of your application, after 18 months, the application will be published for entire public. So after 18 months, anyone would be able to see what is the invention that you have filed and the area that it relates to. And from that time onwards, it will be considered as prior art for anyone else who is creating trying to file a patent on the subject matter. So the publication date is also very important, because later on, when in your course of patent filing process, or even after the grant, whenever you want to sue for damages for someone who has already been creating this products which is infringing, then the damages will be calculated only from the date of publication. It is not from your date of application, because as and when the application is published, only then it goes into the knowledge of people or anyone to look for it. So until then, it is not considered as a period which you can claim for damage. So once the application is published, you can, the next process is that you need to ask for examination to be done on your application by Patent Office. So this request for examination has to be filed. So once that is filed, Patent Office will start looking into your application, will go into the subject matter, will see compliance with the law, what are the requirements, like we saw, what are the contents that you need to be produced, have you abided by the law. So all those factors they will check in. If there is any objection that they see with respect to law or with respect to your contents that you have produced, it is all raised in there. Then there is a response that is drafted and filed back to the Patent Office. The Patent Office, if they still have a objections, they can call you for hearing, or they would issue another examination report. Basically, whatever the process that we are seeing here is all coordinated on your behalf by a patent agent. So finally, once the response to the objection is satisfactory to the examiner, then in all process it will be granted. So if it is not satisfactory, then application will be rejected. So the timelines is also mentioned. So this is the normal process that happens for filing a patent in India. So next one, we'll have to look into the process where, the difficulties that your application might face, or if at all you want to prohibit someone obtaining a patent. So it can either be called as opposition proceedings or revocation. Now, in due course of patent, as and when it is published and before the time it is granted, if someone finds a patent is under progress and it shouldn't be granted, someone who's who might be concerned with the industry, if this patent is granted, it might harm him, or whatsoever reason this patent can be opposed, then in due course he can oppose. That is called as pre-grant opposition. So, but even after the grant, for the 1 year period, he can always file an opposition with the controller before the controller and patent office for the same opposition. So, it can happen for any of your invention that has been filed also. After it is published, you can always expect someone can raise an opposition in patent office. This is apart from the normal, the examiner, that is the patent office employees going through the patent application raising objections. So this is someone like me or anyone in the industry filing an opposition and trying to prohibit someone getting a patent. So today, if you file a patent, when it is published, you can always expect a pre-grant opposition, or after the grant for a 1 year period, you can expect a opposition proceeding in patent office. But the other factor is after what happens after 1 year. So you need to always have a relief measure. If you find some patent is for whatsoever reason it shouldn't be granted, then there has to be a possibility for you to revoke such patent. Like we saw the example of turmeric, which was patented in US. So we saw a reason to be revoked. So now we need to have a mechanism to file an revocation petition or something. So in India, it is called as IPAB. It is Intellectual Appellate Board. So this Intellectual Appellate Board is nothing but it is a tribunal. So it is a patent specialized tribunal. Normally, this is handled by the courts, but courts, not every judge might have specialization in the subject matter that is dealt with. So they formulate a quasi-judicial body. For normally for patent it is IPAB. For tax matters there is one other tribunal. So wherein the process is also streamlined and fast. So over there can be a petition filed for revocation. So that is the takeaway. So later, so one other main factor that we always need to pursue in terms of patent is able to stop others from using the patent that we have been granted. So, once we are granted with patent, now if we see someone else manufacturing goods using our patent or using our method, then we should always have a mechanism to stop them. So this infringement suit can be filed in district court. And what are the relief that we can expect out of that suit is we can claim for damage. So for all the product that he has manufactured and sold from the date of publication. So, or consider having him buy out a license from a patent and make revenue. So infringement suit, also creates an, a concept of fear in minds of infringer, so that, the case could anytime be settled out of court, but, it would give us an opportunity to give, sell out a license to such and such player. So, if not, there is another relief called injunctive relief, wherein, the court might take its own sweet time to decide on the case, whether the player is infringing a patent or not. So in due course, you should have, a right to stop him from manufacturing the goods or selling it or enjoying a profit in due course. So for that, you could always apply for an injunctive relief and stop the player from manufacturing the goods. So that is a right that is also granted. Obviously, you need to file a petition for that. And with all these intellectual property infringement suits, so the one thing is that for any corporate or for any industry who has a patent, and if they need to face such infringement suit, the one major factor is another loss of reputation. So the one case at least you must have heard in, which is famous in India, is regarding the TVS Motors and Bajaj. So now Bajaj sued TVS Motor for one of their patent, and that patent right now the case had gone over for at least 15 years period, and I somehow believe that it was settled out of court right now. But however, TVS came out with a vehicle named as Flame. So you must not have even by now remembering that vehicle name, I believe. So when they had to launch this vehicle, this suit was fine. So now it created so much chaos in the market and created so much of bad reputation in the name of TVS Motor. It wasn't sure whether they were actually infringing or not also. Until now, the case is not decided for the. So the amount of the bad reputation they had to earn in that particular point of time, that itself caused the loss or failure in making the vehicle hit at that point of time. So this is something that is very serious, and a lot of industry would take it very seriously. And so why did we say this? Is when someone makes a product, an industry or an individual, and when you are launching it in the market, so you might or might not have a patent on your product, but then there can be a patent which is already existing in the market in whatever space that your product has to deal with. So you need to have freedom to operate such. You need to see whether you can sell out goods in that domain of whatever space that you want to sell out. So say suppose tomorrow we want to sell a mobile phone. So everyone in this world can do any work. So we can today sit to decide that we'll build a mobile phone, and we create a phone. But today's phone will have to obviously use this 4G technology or anything. There are a number of patents that is available on 4G technology. Now we are trying to sell out the phone. We me on my own created a product. Now I should be able to sell it. I cannot say that. So when I sell it, I might face a number of infringement suits that is coming upon me, because there is already a patent that is existing. So you need to have in mind, before any of the product launch, there has to be a patent search done to ensure that we are not infringing any patent, and then release the product. So this is the major takeaway here in case of infringement. So the picture down gives you idea about what can be the process. I hope that was clear. So the next one is regarding the career option in this domain. So the first and foremost thing in all of the topic that we decided is the creator. Is the creator or the inventor. So someone is inventing an invention, which the betterment of living beings. So that is supposed to be protected, and the inventor has to be encouraged to create more inventions. So that is the foremost career path that you need to look at in this entire realm of whatever discussion we have. You can always choose to be a patent owner. You can decide to be in a career path, technical career path. So, but considering that the focus topic, whatever we discussed, there can be a number of work portfolios that can be derived out of. One major factor is the patent analyst. Like we were discussing, there is this to understand the state of art existing industry, you need to do a state of art search. To know if there is a patent existing or not before you file a patent, there has to be a prior art search. To know if your product will infringe any of the patent that is existing, you need to do a freedom of operate search. So in order to do this, there is a lot of databases. How you search, that's a skill that can be built, and directly out of engineering colleges, people can join in firms which are specialized in doing this and get to learn things. So this profile is called a patent analyst. And next sort of activity is again called patent drafting. So that the complete specification that we saw, some inventor is approaching a patent firm with the objective of having a patent application file. So you basically you do a search, and after that you need to basically get the details and file the patent draft. So this entire process of drafting is a very skilled job. Like we said, the description and then the claims that gives protection, it has a lot of nuances in doing it. So that's a set of skill also, it's very promising, and you don't see right now the patent filing is increasing at an enormous rate. So this is another portfolio that you can look at. And once you draft and then file it, there is you need to be patent agent to do it. After filing it, the prosecution, examiner would raise an objection corresponding with examiner to a written mode, and if at all a hearing is called for, you appear before him and then convince him to grant the application. That is not the rest of work. So these are the profiles that you can look at. So straight out of engineering, once you finish your degree. So but you will also be able to be a patent agent. So the minimum qualification there is an examination that is conducted by Indian Patent Office. So as and when the examination is called for, you can apply for it. The minimum qualification, like I said, is engineering. You can apply, but you need to read through the entire patent law that is there in India to be able to clear that exam. So once you are through to patent agent, so then you could seamlessly handle this portfolios that we talked about. And patent licensing, patent is granted. Now, after patent is granted, there has to be some purpose for it. Either you manufacture the good and sell it. In all possibilities, it might not be the inventor manufacturing the product. An individual inventor cannot go about manufacturing thousands of products and enjoying a commercial space for himself. So, the other possibility is that you license out a patent to big entities or making a product in that segment and make money out of it. So patent licensing and monetization is the other portfolio altogether. You need to gain specialization over a period of time, maybe in handling the, the previously discussed portfolios in order to be able to do this better. So, but nevertheless, this is another portfolio of work that is still existing in this field. So then the other one is patent litigation. So in order to litigate, you need to be an advocate enrolled with the Bar Council of India. So in order to do that, you will also have to do a law degree. So that can be a least preference at your stage. So then the other, whatever we discussed is the realm of jobs that is available in private industry or private practice. So then there is another set of jobs that is possible with the government entities. Now, patent office is run by again ministry, one of the Ministry of India, and when we say patent is filed, there has to be a qualified person who can check out these patents and see if it is all according to law and raise an objection or grant the patent. So all these to do that is a team of people who are sitting in there who are called patent examiners. So for these patent examiners, Government of India calls for exam, and engineers can apply for it. Engineers or masters in engineering people can apply for it, crack the exam, and then be appointed. So that is altogether like any of your, you also get to be in the technical domain and then be in a government job. So you can look at it. So this other two categories that I have put in, scientific advisors, so it is very specialized profiles. It is for someone who's very has a wide range of experience, who have science, engineering, technology degree, and who at least have minimum of 15 works experience in practically in these fields or in research departments of any of the central government organizations or private organizations. So, but I would say maybe it is more suitable for right now for the faculty members. So, if any one of you are looking forward to being a scientific advisor, you can look for notification that is being published by the patent office. So, this main purpose of scientific advisor is nothing but the patent office is controlled by the controller. So, and the controller is the one, mainly it is IAS officers who are appointed for this post of controller. But it is job and duty of controller to maintain the scientific advisors list. So as as and when they call for people to be enrolled, so scientific advisors are enrolled, and then the list is maintained at the patent office by the controller. So when there is a litigation happening in any of the courts, so when courts feel that they don't have expertise in technical matters, and if they want some expert to help them out or guide them in their process of deciding a matter, they would approach the controller and patent office to give them out the list of scientific advisors. So looking at the scientific advisors and the domain that they are specialized in, a court can appoint you as an expert to guide the court in that in the subject case. So this is another realm of opportunity in this space. So the next one is the IPAB technical matter. Like we said, IPAB is Intellectual Property Appellate Board. It is a tribunal to handle the patent cases. So before it can reach any of the courts. So now this IPAB is constituted by either it's a quasi-judicial. I mean, when we say quasi-judicial, it has both legal personalities as well as member from technical community to handle the case together as a joint forum. So, but unfortunately, or I don't know for what reason, it would, on this day we have only one technical member representing in IPAB's board. So, but I feel there is a requirement for a lot of resources, and probably there can be a notification issued. So this again requires all these 10 years the person should have registered and practiced as a patent agent, should have had these qualifications. So it is again, you get a chance to sit side by side with a retired judge to decide on a matter that is before you. So it is one of the reputed profiles, I would say. So with this, I think we have come to end of this session. Maybe we look into questions, whatever has come out.
Yes, sir. Thank you very much. It was very interesting, sir. On to the questions. I'll just see the questions, what are posted there in the box.
Yeah.
The first one by our Professor Mr. Sadasivam. Why Indian researchers prefer publishing research papers over filing patent application?
And preferences according to individual expectations, but I would say both should go hand in hand. I mean, it should every other person in academic field would want to always publish papers. They shouldn't stop with that. They should also go for patenting. Now, the one main point that you need to take care when you want to both hand in hand is that you need to have filed an application, or within 1 year period of filing presenting or the publishing the paper, you need to have filed the patent application. So this has to be in your back of mind, because your own publication or the presentation would would be considered as a prior art when you later go for a patent application. You wouldn't want to face the situation. So like I said, it shouldn't be stopped with just publishing a paper or presenting a paper. I believe also you should take it forward with patent filing. So you have larger benefits with patent filing.
The one that is published, can it be patented, sir? Is it possible? We'll have to do something, little more work on it, right, sir?
It wasn't audible. Can you be a bit louder?
Oh, just a minute. You're able to hear me now?
Yeah.
No, the one that is published, can it be patented also? Or some more work we are supposed to do on that, right?
Yeah, like I said, from the date of publication, within 1 year, you should actually file the complete specification.
Okay. After publishing,
longer. So if that.
Yes, sir. Continue.
Yeah. So if you published an paper, okay. So if there is already 12 months period cross, then it becomes it already has entered the public domain, and you cannot anymore file for patent. So at least if the period is not crossed, then I would say you need to take all measures to see that the patent is filed. So if the period is crossed, then maybe you need to keep this in mind when you face such a situation in future.
What will be the approximate time duration, sir, from applying to patents granted?
Yeah, so right now I would say there is a process of expedited examination in India. So by using that mechanism, we could have it obtained pretty earlier. So when I say pretty earlier, it can be anywhere around 1 year to 2 years, or max 3 years. So on average, when when we say expedited examination, it also involves cost. So the normal cost and patent filing process, right now it can take anywhere between 4 to 5 years. But this itself is an improved period, I would say. From the time where we in, we would have likely taken some 7 to 8 years, some 2-3 years back. So right now, I would see that in days ahead, we would have this period further reduced, and probably we have patents granted fast. But if it is a startup or a women inventor, there is also concession in a lot of these fees, and for the expedited examination also shouldn't be that expensive for an inventor or a startup.
Okay.
Kavita ma'am, I just have one related to this. I have one more doubt. Actually, it's a problem. Suppose you take situations like COVID, where you want to do something filing at the earliest. Even that expedited, it takes 1 or 2 years, right? So how do you manage that? And also the rate at which the technology grows. Even 1 year, the next technology comes up. So, I somehow feel like in India, the patenting processing time is too much to compared with the technology growth rate.
Yeah, ma'am. This, like you pointed, maybe the grant comes later in India, so that I cannot disagree. But however, you see the patenting process everywhere in the world. I mean, the process that we saw in one of our slides. So that process largely remains across jurisdiction the same. So when we say it is same, so from the time of filing the application, for the application to be published, I mean, when it is published, it enters into public domain. So until that time, the 18 months period is very constant time. So across the globe. So I understand the technical, the technology might also not be stagnant. It will keep evolving. So the point here is that, so you reserve your date. As and when you file your application, you reserve your date. Nothing there stops you after filing an application to exploit your invention. You can always commercialize your invention. The only point is, in due course of patent being processed or not granted, you cannot go ahead and file an infringement suit upon another person who is infringing your patent. But always you can do that whenever your patent is granted. You can always do that. You just need to keep collecting the evidences in intermediate stage, and simultaneously you can keep exploiting your invention. There is no harm to it. So your damage claim for the particular invention can be always backdated and claimed at the future date.
Okay. So that's how the industry should be working also, right? So
yeah, exactly.
Yeah. Okay. Okay. Thank you.
Thank you, sir. The next one, whether patent applying process is easy for individuals to file, or should we go for some other agencies or brokers to do that?
Okay, like I was using these terms patent agent. So in India they are called as patent agents. So in other part of world you would call them as patent attorneys. So I know these are the people that you always need to engage to be able to prosecute and file an application and prosecute application in patent office to obtain the patents. So yeah, as an inventor, you yourself cannot go ahead and approach, because there are so many technicalities that is involved in, you must be master of your invention. There is no one else who knows better, apart from you, the invention that you conceive. But however, in order to be able to be put in the paper in the structured format or the expected manner, or to, to have the industry practice of giving you the best protection in terms of the claim that can be drafted, this can be done only by a skilled person. So unless you gain that expertise, I mean, all of you are from technical background. You can anytime give a patent agent exam and clear that. The minimum criteria for that patent agent exam is that you need to be equipped to handle such a portfolio. So when you read and equip yourself and then build your expertise on your own, you can do that. But in order to be able to do that, you also have to be a registered patent agent. So until you are a patent agent, it is best to approach a patent agent to do that. So it can, any law firms who do that, or individual patent agents can also do that.
Okay. We'll be charged for that, right, sir?
I did not get you. Can you come again, please?
No, we will be charged for that, is it not?
Yes, exactly, ma'am. So for all these patenting procedures, there are some official fee. I mean, patent office itself will charge you for fee at different stages that we were talking about. In addition to that, for the patent agent might charge you service fee for his service.
Okay. Okay, sir. Thank you. The next one.
But it always depends on the, the patent agent or the firm that you have approached. It depends upon the quality of work that they render. It depends upon the firm's charging. So it cannot be a standard charge. So however, the official fee will remain the same.
Okay, sir. Thank you. We have few more questions. Shall I continue?
Yes, ma'am.
Okay. Is it a problem if I'm using a clip art for my business logo?
Okay, so this is like in the presentation that I made, you would have seen a lot of images I have taken up and used. So all these images I did not create by myself. So some of the images, in Google, if you are searching for the images, in the tools option, you also have an option to say to select the search results depending on in the rights to reuse, rights to modify, all those you will find. So basically whatever we are talking about is the copyrighted subject matter. So now you need to find images which allows certain rights for your use or for modification. So those image you can take it and use it. So whatever I have used, maybe some of them are I have rights to use, some of them I don't have rights to use. But largely this is for academic discussion, which has an exception towards it. It's called fair use under copyright law. So for fair use, I can use even the copyright material to convey the knowledge. But however, whatever you are right now denoting is for business logo. For business is a commercial exploitation. For that, unless until some of the images is explicitly grants rights for your use, you cannot take it up and use. And additionally, I would say that for business logo, you do not download from anywhere and use. So you should have created by your own, because unless until you create a logo by your own, you cannot apply for trademark. I mean, over a period of time, you run your business, you have gained your customer base, you have gained the product reliability factor in the market, but you need to establish all those goodwill by your own business logo itself. So in order to be able to apply for trademark and obtain it, you should have created all of it by your own, or you should have engaged some entity or any person who can do it on your behalf.
Okay, sir. Thank you. The next one, it's related to maybe cinema. Who has more rights, musician or lyrist or the producer?
Yeah, so this we are facing a lot. You would have also seen Raja
Yeah,
filing.
it's maybe based on
So
that.
there was, yeah, there is also some turmoil between SPB and Raja. So the problem that we see is, producer is the one who funds entirely. So like we see for any of the employee who works with an organization, if the employee in the due course of work comes out with a an invention or a copyrighted matter, automatically it is assigned to the employer. So because the employee contract addressed to it. So, but in case of this, initially maybe in film industry, that's how it was. Whoever funds it, automatically all the rights are granted to it, granted to the producer. But right now, in all the engagements, we don't see that happening, because a lyricist has their own contribution to make in terms of lyrics, or a musician has his own contribution. A sound mixer even has their own contribution. So everyone has their own contribution in their work contract. However, they have come out with an understanding of sharing. When a song is finally composed, so who will own what part of IP, or they internally have this classification already in understanding. So that is how it goes and splits. So the problem with Ilayaraja was he had been in industry for a quite long time when all these laws were probably not known, or were practically being used. So for all his older songs that he had composed, so he had not got a lot of these agreements in place. So that is why when his claim is rightful. So when he goes and asks for, ideally it created a bad name on him, but ideally his right to claim for having this part, I mean, for whatever contribution to be paid is a rightful claim. But since because there wasn't an agreement to it, he had to file a suit for it. But otherwise, everyone, I know it ideally boils down to the contract. But right now, I see a situation where everyone would rightfully claim their right, and they would not directly grant to the producer all of their rights. And at least they'll be able to earn royalty towards whatever they create.
Okay. Thank you so much. The next one, the one that I too wanted to ask, what is the success rate of patent in India, and where do we stand exactly?
So success rate, ideally, this is not something which is a publishable data. There can be n number of, like I told you. So there was also a question that whether I can go ahead and file a patent. So the point is here, either the invention is, a not well-conceived invention. So that being one factor. Another thing is that even if the invention is a well-conceived invention, due to the fact that it was not drafted properly and due to a number of objections that is raised, it can go as ungranted. But to streamline this process, I would say it is always better to approach a well knowledgeable and who can give you a proper service in terms of drafting the application and prosecuting it. So otherwise, the success rate of as such, If you are sure that a patent is a, like I was suggesting, for conceiving a solution, you can always refer to the database to look at what a state of art that is existing. And you can on your own search, obviously, you will know your invention. So you can derive out the keywords out of it and enjoy maximum. It is, anyone can do it. If you are able to use Google, you can always use these databases as well. So to understand if there is a patent that is existing or not, which will there be a patent that will be construed as prior art. So if you have ruled out all these possibilities, and if you have figured out that there is a inventive step that my invention gives and it is new, then in all cases it has to be granted. I mean, at the max, what you can wait is that see what examiner has to raise an objection. So these objections, we should not treat it in the way of rejecting our application. We should just, we have confidence over our invention. We should treat it, how do we convince the examiner and claim as much as scope in our patent. At the max, what the examiner would do, or the controller would do, is to minimize the scope of our claim. But our whole purpose here is, we have conceived the invention, we should get the maximum scope as possible. So that should be our approach, I believe. When we have followed all these norms, I believe the success rate normally comes in there. But outside, there are also a number of patents which are not well conceived and well drafted and result in a lot of failure as well.
Approximately how many patents do we file, sir, per year in India?
In India, like in one of the, we have somewhere around 10,000, I believe. In one of the slides we have added this data.
Okay.
So if you, this slide, it gives China as the leading patent filing countries in entire world. Okay. So India files around somewhere, I think 110 to 1, it can be anywhere around 20,000.
The next one. Okay.
Yeah.
The next one.
Yeah.
The next one is patent application disclosed to public.
Yes. Main purpose of patent itself to disclose it to public, and in turn government grants you the monopoly right for 20-year period. So when we say it is disclosed, when you file the application, it goes on record with patent office. At the stroke of 18 months, when the publication has to happen, patent office will publish it. So right now, when we are talking about all database, you go check a database for seeing if there is a prior art existing. So when we say database, it is all nothing but there is all the whatever patent that is granted or already published, it's available in the database. We are doing a search there. So automatically, when every patent which is filed will be published, will go into public domain. But when the patent is successful, you are granted the patent and you can enjoy monopoly. So the main objective is that you disclose and then enjoy the patent.
Okay, sir. Thank you. The next one, can we withdraw a patent once filed?
Yes, it is possible. So now the point is, we discussed that at the stroke of 18 months, the patent will be published. So, if you intend that your application should not go into public domain, then before 15 months, it has to be withdrawn. Okay. So if after 15 months, if you are filing a withdrawal application, then the patent is already there in public domain. Maybe you might not be able to refile it without again building up another inventive step over whatever you have discussed.
Okay, sir. Thank you. The next one, who's the authorized person for applying geographical indications? What is the practical step do we have to take to obtain GI?
Yeah, GI, I'm not exactly sure, but what I can say is that, it is again, like patent office, we have an IP patent office in Chennai. So likewise, in the same office, we also have trademark registry and geographical indication registry. So over there, application has to be filed, but this application is not on behalf of an individual, but it has to be originating from a community. It is a community right. So, the geographical indication exists for Kanchipuram sarees. exists for Dindigal locks. Dindigal put Tamil சொல்லுவாங்க. So they, there are these are rights that is enjoyed by the community. So the entire community on behalf the application has to be filed. But I cannot comment about on the process of the application. I am yet to look in for that. But what I am sure I can assure you that it is not an individual application, but it is a community-based application.
Okay, sir. Thank you so much. All the queries, I think it's answered.
I have one more query.
Yeah, continue, ma'am.
Yes, please.
Actually, when we are filing a patent, there are something called as applicant and inventor.
Yes, ma'am.
But generally, what happens is who is getting the benefit actually? If, for example, if my patent is granted and then I get some revenue out of it.
Mm-hmm. Okay, so like we were discussing this concept, the employee-employer relationship. So when you say inventor is the one who has conceived the invention. So ideally they are tagged as inventor in the application. Now, when there is, you are not in an employable position, and if you are alone filing that, you would normally be the applicant as well. So, so applicant will finally be the patent owner. So in case of employee, when you are in an organization setup, and whatever you invention that you conceive will automatically be assigned to the employer in way of your employment agreement. Then in all the applications that you are filing for your patent, so you will be called as inventor, but automatically the applicant will be the employer, and the employer will be the patent owner finally. So this whatever we are talking about in terms of royalty is something that is agreed between the employer and employee. So it can either be included in the employment agreement itself, or there can be a separate assignment deed which is signed when the specific patent invention is assigned to the employer. In that deed, they can talk about the royalties as well. In India, we do not have a very big evolved, the inventor appraisal mechanism. We don't have that as part of law itself. This employee, renew either royalty sharing or the appraisal mechanism for filing a patent is based upon the individual organization's approach or their own policies. But in some of the Western countries, at least in Germany, I know there exists a law by itself wherein the inventors, when they conceive the invention, and when even the applicant be the employer, there is a from the time it is conceived, what is the appraisal that you need to give. So for every stage there is a well-defined renewal appraisal practices in Germany. So that is by law. But in India, we don't have such a law existing. It is upon the individual practice of the organization.
So the employer will be gaining more than the inventor.
Yeah, exactly. So the point is he creates the environment, and then he provides you with all necessities to make you create inventions. So by that means he is taking away all the rights. Okay. By either you can always conceive invention outside your employment realm as well.
Okay, thank you.
Thank you. That's all for the questions, sir. Thank you so much. I thank Mr. Sathya Sundar on behalf of our college and department of ECE. I think we all got a better understanding of IPR. I thank our professor, Dr. Tulasi Bai, for arranging this webinar. Thank you, our Associate Dean, Dr. Sathya Sundar, for helping us in conduction of webinar. Thank you all participants, staff and students. Take care, stay safe, all of you. Thank you so much, sir.
Thank you all. Thank you for this wonderful opportunity. I hope I was able to convey some of my knowledge